Court of Appeal, District, State of Florida is now in session. Now, Richard B. Orfinger, Judge, presiding. All persons having business for this court draw near your attention, you shall be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to the 5th District Court of Appeal. We're happy to have everyone here. We also have an afternoon session, so if you're here for the afternoon, you're a little bit early. We have had one case that was continued, that's Cannon versus U.S. Bank, so in case you're here for that, you might want to go home. Other than that, we'll take the cases up in the order that they're on the docket. Let me first introduce the panel this morning. Sitting with me this morning on my right, your left, is Judge Tom Sawaya, and this is Judge Carrie Evander. If you have a cell phone, we'd appreciate it if you would silence it so that you don't interrupt the parties. We have 2 criminal matters first, and so the parties will have 15 minutes per side, and if the appellant would like to reserve some time, just let us know and we'll set the clock accordingly. So with that, let's go ahead and call the first case, Michael McComb versus State. Good morning.
Good morning. May it please the court, Counselor. Steve Gosney, Public Defender's Office, on behalf of Mr. Michael G. McComb, and this is the case. I first want to get out of the way. In my initial brief, there's a misstatement of law on page 7, which says that there's a state on page 7, both of which State must disprove the affirmative defense beyond a reasonable doubt. That's not correct. Duress, the due process clause does not require duress to be disproven by the State beyond a reasonable doubt. It should be compare. Anyway, I wanted to get that out of the way.
I'm sorry, it should be what?
Should be compare those cases, because the case of duress in the affirmative defense of a duress is much different from the affirmative defense of prescription.
I didn't hear what you said. Okay.
And that really gets to the crux of the argument. The issue in this case is who bears the burden of proof in the affirmative defense of the agent as of a prescription holder. So if you are an agent of a prescription holder and you raise that affirmative defense validly, does the burden then shift back over to the State to disprove that affirmative defense, that you are not lawfully possessed of this drug?
Was that argument raised below?
Let's see. Was the argument raised below? I don't believe so. The issue was raised in the fact that the jury instruction was given. The affirmative defense jury instruction was given. But
didn't defense counsel agree with the jury instruction that was given?
The jury instruction, well, there was a lot of discussion on that, and there's some confusion about whether they agreed to it. There ultimately was a jury instruction given on that affirmative defense, and it was agreed to in the end by defense counsel. But there was this discussion about, it's a long, you might want to review the record on that, there's a long discussion about who bears the burden of proof there.
If it was agreed to by defense counsel, then would you have to show fundamental error on appeal?
Yes, and I think that there is fundamental error here. Okay. Because the affirmative defense, if you are lawfully possessed and you raise that validly, which was done here, the question of who bears that burden goes to the Dixon standard, which is the U.S. v. Dixon. The existence of duress does not contradict an element of defense. The State must disprove the affirmative defense because the evidence that tended to prove valid prescription also tended to disprove an essential element of the offense charged. And here, the illicit nature of the substance is an essential element of the charge. The due process clause requires that the State...
That's not an element. This is an exception saying that if you are an agent and have the permission to acquire the prescription and to have possession of the drugs, that's not an element of the offense, is it? That's an exception. Well,
it would be if somebody is lawfully possessed. OxyContin is a a drug that can be lawfully possessed and is lawfully possessed by prescription holders and agents of prescription holders.
I know, but you have a statute that says this is the crime, and then we have an exception that says if you are an agent and you have the right to acquire the prescription and obtain possession of the drugs, that's not an element of the offense, is it? That's an exception.
Well, but see, that's what I think is the crux of the matter.
Well, is it an element of the offense or not?
Well, the question then is if everybody who possesses this drug is a felon, and then they have to prove that they're actively licensed or rightfully holding it, or is that something that the state has to prove that it's an illicit substance when possessed by this person?
If I say it's not an element of the offense, then that leads to the next question. If it's not an element of the offense, is it fundamental error for the jury instruction to simply say, as it did in this case, that the defendant has to prove by competent evidence that the exception existed? And that's basically all the instruction said, didn't it?
Right.
It didn't say that he had to prove it beyond a reasonable doubt. It just said he had to present competent evidence that the exception existed. So if that's the case, and it's not a burden shifting of the element of the offense that the state has to prove, how is that fundamental error?
Well, and this is the question. What happened was the state presented its case.
Right.
The defense then comes forward with competent evidence that raises this affirmative defense. The question then does it go to the fact finder to believe or disbelieve the jury instruction, or they'll believe the evidence that was before?
It seems to me the question is it fundamental error? And that's why I asked you in the beginning, is this an element of the offense? And I don't think that it is. I think it's just an exception. And if it's an exception and there's no burden shifting of the state's requirement to prove the elements of the charge beyond every reasonable doubt, and we have a jury instruction that simply says he has the burden of producing competent evidence, I have a hard time equating that to fundamental error.
Well, and I think if we take that, that's really getting to the heart of my argument, and that is, is OxyContin possessed by people? Are they all felons? And then they are brought into court, and then they have to say, yes, but I have a prescription, or I'm an agent, I'm somebody who handles these regularly. And then the jury has to believe or disbelieve that person's story? Or is the state brings it and says, this person's possessing OxyContin?
Well, apparently the jury had a difficult time believing the story because there were some inconsistent statements that were made by the defendant at first appearance, and there were some facts that were brought out. For example, the other witness, the lady said that she didn't leave the drugs there because there was someone there that was a drug abuser that stole their drugs before, so their policy was just to take all the drugs away, but he left some there and kept some in the bottle, and there were just a lot of inconsistent statements that just didn't make a lot of sense. So apparently the jury didn't believe the competent evidence that the defendant put forth, saying that, well, this exception applies.
Well, I'd refer you to my reply brief on those to rebut the points. There's 4 points that they make that saying inconsistent. I'd argue that none of those quote, I'd say are very weak inconsistencies. He left his own pills in the trailer but took hers, but she asked him. That's sort of I think doesn't have anything to do with whether or not he's lawfully possessed.
Yeah, I read
the different section of first appearance. I just review my reply brief on that. But finishing the other point, I think that once the person says, okay, I'm lawfully possessed of this, and I raise that with evidence, and then does the burden then shift back to the state to say, okay, no, but you are unlawfully possessed?
One other question, and I think I'll have exhausted all of mine. And my question is that every time there's an affirmative defense in a criminal case, does that automatically and necessarily mean that all the defendant has to do is raise it and put forth some evidence that the affirmative defense may exist, and that shifts the burden to the state to disprove it beyond a reasonable doubt? Is that necessarily the case every time there's an affirmative defense in a criminal case?
No, absolutely not. In fact, that was what the Dixon standard, the U.S. Supreme Court Dixon standard, about when does the due process clause require that shift back to the state to disprove the affirmative defense, and that's when.
What is it about this particular affirmative defense that would require the state to disprove it beyond a reasonable doubt?
Well, because it's the illicit nature or the knowledge of the illicit nature of the substance. If you are rightfully possessed of the OxyContin, Does the state have to prove that you're not lawfully possessed? I mean, that's really the question. Does the due process require the state to prove that you're a criminal, or do you have to disprove that you're a criminal to the state? And if we if we don't shift that burden over, then the due process clause, I think, is violated.
It seems to me that if we accept that argument, then every time there's an affirmative defense in a criminal case, the state automatically has to disprove it beyond a reasonable doubt.
Well, that's why I said compare duress, because a case of duress, that's a case which says, okay, I knew it was criminal, I knew what I did was wrong, right, but I was forced to do it. In a duress situation, those are new facts that are brought in that are outside of the case. It doesn't mean it's not illegal and it's not against the law, it's that I had an excuse. In this case, we're saying, is everybody a criminal who possesses these drugs? I think it goes to the essential nature of the case of whether or not these drugs are if somebody who's a lawful possessor, should they have to prove themselves innocent? And there's a case actually right on point, Wright v. State, that this court in Spicer referred to, which is 442 Southern 2nd, 1058. And it's the point of law that I cited to using Smith and Spicer was Wright v. State. In that case, there was a screwdriver that a prisoner had. And, of course, a prisoner with a screwdriver is a weapon in any kind of prison facility. When he comes up and he gets in a fight and he's searched, and they say, aha, a screwdriver, it's a weapon. Well, normally that's contraband. And then he says, yes, but I was given this screwdriver because I have a job in this prison. And then in that case, they said the burden must shift. That was, I think, the first DCA. The burden then shifted back over to the state to disprove the affirmative defense of whether this is an illicit weapon. The screwdriver was illicit. And I think the same thing goes here. Possession of the drugs, is that illicit? Just by its nature, is it illicit? Once I raise that validly, does the state have to prove that it's illicit? And I think that we are required to do that. I'm sorry, I'm taking too much time. If I can reserve anything, I will.
You've got 4 minutes, 53 seconds.
Okay, I'll reserve that. Thank you, Your Honor.
May it please the Court, Counsel. My name is Lori Hagan. I represent the Attorney General's Office for the state in this appeal. I'd like to address the second issue first, since the Court, I believe, had more questions on that, and that is the jury instruction issue. And I did want to point out that not only did the defense counsel not object to this, but he specifically proposed the instruction that was given in writing. And there was some discussion about other aspects of the instruction, but as far as who has the burden of proving it, he specifically requested that. And there's numerous cases from this Court and others saying that if you...
Do you think that this is an affirmative defense that requires the defendant to do nothing more than raise it and put on some evidence that it may exist, and then shifts the burden of the state to disprove it beyond a reasonable doubt?
No, I don't. And I think...
Why not?
And I think if you look at Dixon, which opposing counsel cited, Dixon explains in detail that if you look at the elements of the offense, here you have, all you have to show here for the elements is possession of 4 grams or more of oxycodone, and that the defendant knew it was oxycodone. And then if you look at the affirmative defense, which requires that you had a prescription lawfully obtained and you were acting as the agent of the prescription holder, that does not go to any of the elements of the offense. It's completely extrinsic evidence.
No, but self-defense, once it's sufficient evidence to raise the issue, the state has to prove the lack of self-defense in a battery case beyond a reasonable doubt, correct?
Yes.
All right. Well, it seems to me if I have a prescription for OxyContin and I go and pick it up and I get stopped for a traffic violation and it's there, and I have the pill bottle with my name on it, I have my prescription or whatever in the other hand, and the state decides to charge me anyway, and I put on this evidence, why shouldn't the state be required to prove that there's something wrong with me being in possession beyond a reasonable doubt when I've raised that level of evidence? Why should I have to prove it by preponderance of the evidence?
I mean, under Dixon, that's exactly what Dixon holds, that you have to prove it by preponderance of the evidence before the state would have to disprove it by a reasonable doubt.
Well, no, I think, like the self-defense case, I just have to raise it. I just have to present enough evidence to raise the issue.
Okay.
And assuming I do that here, why shouldn't the state be required to prove guilt beyond a reasonable doubt?
Well, they
on
always
that
have to-
issue.
I'm sorry, they always have to prove guilt beyond
Right,
reasonable
right.
doubt.
Why shouldn't the state be required to prove that I didn't have a prescription beyond a reasonable doubt when I, put on evidence that I do have a prescription and that I...
Well, I think in Dixon, they even pointed out that if information is particularly within the knowledge of the defense, it makes sense to require them to prove it, and rather than the state disproving it. I mean, how would the state necessarily be able to ever disprove that? I mean, especially the agency relationship. I mean, the defendant has to carry the burden to some extent to prove it. So if the information is particularly within his knowledge, he has
Well,
the
I think
burden.
the question that Judge Evander is trying to get at, though, is once the issue is raised, in other words, let's assume that he had come to trial and he hands to the jury, puts into evidence a healthcare surrogate, a power of attorney, a sworn declaration from the patient that says, I've authorized him to go to the drugstore and pick this stuff up for me. What happens at that point? And let's assume that you have no reason to quarrel with the authenticity of the documents.
Okay.
So what happens now? He's produced competent evidence that he's an authorized agent. What happens to the evidentiary burdens at that point?
I think... I mean, if you're looking at the jury instruction, I don't think there's any... We don't have any law on that as far as specifically what the jury instructions could say, but, I mean, the case law in general says that if the defendant presents competent evidence, the state must present evidence or testimony either through inference or its case in chief even, which contradicts his innocent explanation. Now,
So laying aside the inconsistencies here, and I recognize that there are some inconsistencies. I mean, would it be a crime in your mind, for example, if my mother was taking OxyContin and because of her condition she doesn't drive, and so she says, can you drive by Walgreens and pick it up for me? So I go pick it up, and it's in a bottle, it has her name, and I'm driving home and I get stopped and they say, you got any drugs in the car? I say, well, yeah, I've got this nice fresh bottle of OxyContin. Is that a crime?
no.
Okay, so now when I get on the witness stand and I say, this is what happened. Mm-hmm. The state charges me with possession or trafficking, whatever they want to charge me with. I get on the witness stand and I say, okay, well, Mama doesn't drive and yada yada, this is what happened. What happens to the evidentiary burden, assuming that that's competent evidence?
The state has to present something that contradicts your innocent explanation.
And if they don't, is it a DV? Is it, what happens?
Yeah, it would be a JOA then. Of course, they would have to do something. I mean, all the cases say that. But they don't have to. They can just do it through impeachment. They can just bring out, actually, they can just point out, or it can be, there can be an inference from your testimony that what you've presented is not reasonable or is, inconsistent. I mean, that's all they have to do.
Let's assume the state brings up some inconsistency in the testimony the hypothetical Judge Orfinger just gave. All right, so now it's enough to get by the directed verdict and it's going to the jury. Should the jury be told an affirmative defense has been raised, you have to show that the state has overcome that by reasonable doubt, or do you say that the defendant has to prove that affirmative defense by the preponderance of the evidence? What should the jury be instructed in that situation?
I think if you look at the proposed jury instruction that the defendant submitted here, which it has to do with, it sort of encompasses the prescription defense in an agency relationship. It's the proposed instruction for temporary possession for legal disposition of a narcotic or of a controlled substance. And I think if you look at the comments to that proposed instruction, they recognize that the law is not clear at all in this, that if there's not a statute addressing the defense, that you should look to common law. And common law says burden of production and persuasion is on the defense. And I don't know exactly what the instruction should be. And you know what? The issue's not before this court because he got what he asked for. He asked for this instruction. He got it. It can't be fundamental if it didn't go to an element of the offense. So
Might be an issue for 3850 motion.
well, I mean, yeah, it would be. And I still don't think he could show any sort of fundamental error here, especially not under these facts. If the court does have any further questions, I rely on my brief.
Thank you so much.
Thank you.
Your Honor, the question that I think it is, this is a very fundamental question that's before the court, and that is, we're dealing with conduct that can be rightful or wrongful, depending on the circumstance. Just that's the battery exception you're talking about, the self-defense exception. Hitting somebody in the jaw can be rightful or wrongful, depending on the situation. It can be not criminal at all, or it can be severely criminal. Well,
Gosney, let me ask you this. 893.10 subparagraph 1 says, it's not necessary for the state to negative any exemption or exception set forth in this chapter in any indictment, information, pleading, or in any trial, and the burden of going forward with the evidence with respect to any exemption or exception is on the person claiming its benefit. So what impact, if any, I mean, that seems to be precisely what trial counsel here contemplated, and he framed the jury instruction, and it's difficult for me to imagine that giving him exactly what he wanted creates a problem, particularly in light of that statute.
Well, and I think we're dealing with a bigger question here regarding this issue than even just this case. I know my client has I don't believe that the state raised any kind of evidence to contradict his defense once he raised it. So if the burden shifts back to the state, then he's not guilty because they didn't raise anything. So there was 4 points that were raised, and I think I
but you don't disagree with the general principle that if I get charged with possession, and I get on the witness stand and I say, I have a prescription, and I don't tell them where, I don't tell them from who, I don't tell them why. I mean, I just say, I have a prescription. I was prescribed this by a doctor. I mean, do you think that's enough then to shift the burden?
Well, I mean, that's
Is the jury supposed to guess what doctor in the world or why or where I got it filled? Or?
Well, that's why the judge, there is that competent and substantial standard that something that has to come forward, there has to be something competent to be brought forward for that instruction to be given, which is what happened here. The state presented its bare bones case. The judge says, okay, he's entitled to the instruction. But then we didn't take the next logical step in that the burden should be back to the state to disprove that affirmative defense. And that's a question for the judge. In fact, in this case, it was given. Now, does the state then have to raise some evidence or disprove beyond a reasonable doubt that affirmative defense? And in a self-defense context, the due process clause says yes, because this is behavior that can be good or bad depending on the circumstance. And it's the state's burden to prove based on the due process clause. Going back to Blackstone, in Blackstone, all affirmative defenses were to be raised by the defense, were to be proven by the defense. But there's
also case law that says that affirmative defenses that are the burden of the defendant to prove are perfectly acceptable. And the affirmative defenses where the burden shifts to the state to disprove it beyond a reasonable doubt are generally those where the Florida Supreme Court has said, we are saying that this is one of those affirmative defenses where the burden does shift to the state. Other than that, isn't the general rule that if there's an affirmative defense, and I think the case law bears this out, generally it's the defendant's burden to raise it and to prove it.
Well, there
are a number of cases from the 4th DCA and I think some from the 1st that say exactly that.
Well, and the question I think for this panel and for the larger legal community here is this one of those that's required to be disproven as in self-defense or in the possession of a weapon as in the Wright case? Or is this in the category of duress, which is something that's kind of brought in that's outside of? Does it go to the elements of the crime? But I think
this is simply a statutory exception. I don't think that it goes to the elements of the offense that the state has to prove. It's an exception.
Well, we have a bigger problem here, and that is the preservation issue.
Right.
So unless it's fundamental error, I mean, that's the first hurdle And that's frankly the big hurdle for me is that, you know, not only was it not preserved, but you got what, not you personally, but your client got what he asked for. But
Well,
I think
and-
you've exhausted your time.
Oh, okay.
And
Thank
we
you, Your
appreciate your argument, and you
Thank
can
you.
stay there or reload for the next
Honor.
case. Thank you, counsel.